Now, the defense in the Senzo Meyiwa murder trial says the High Court in Pretoria has no jurisdiction to hear the matter. Advocate Malesela Teffo, who represents 4 of the accused, claims his client's rights are being violated. Meanwhile, some are accusing him of trying to delay the case. For more on this, we are joined by legal expert Mpume Zikalala. Thank you very much for your time, Mpume, here on All Angles. I'm interested to know your thoughts about what happened yesterday with that explanation by the National Director of Public Prosecutions, saying that, in fact, that docket number 375, which says Kelly Khumalo and should be charged, has no merit. How do we go forward? Because now the evidence is before everybody.
But what's important on that one is that there are various statements that were taken. Now, a person cannot say, at the time of drafting this particular statement, I was not speaking the truth. One of the reasons or one of the conditions of a statement being written is that you swear under oath that everything that you are going to say is the truth. So it's up to the state to say these are the witnesses in which we are going to use. And as a tactic, the defense can then come back and say, if you're not going to use particular witnesses, and they've written statements such as these ones, we are going to use them as part of the defense. Honorable Court, please issue us a subpoena so that you can be able to call them, so that they can go into the witness stand and tell us exactly what happened. In this particular case, the evidence of the person who saw or was part of the cleaning of the beer bottles and on all the other things that are there, as alleged, would be very important in this case to prove that at the end of the day, they were dealing with a scene which was contaminated and did not reflect the true reflection of what actually happened on that day. So it's the tactic of the defense, I think, is to say, if you don't want to use these witnesses, give them to us. We're definitely going to use them, as we are going to issue subpoenas, so they're able to go to court and provide all the other doubt instances that will be able to help our case at the end of the day.
And obviously, whatever is in that docket number 375, the defense has said that they will definitely use during cross-examination, which actually goes against, some of the witnesses. For instance, Sergeant Musia, who's currently on the stand or on the witness box. Some of what he says in docket 375 is different from what he said in docket 636. So that's going to be quite challenging. But in terms of, moving forward and the behavior of Advocate Malesela Teffo, I thought that what Advocate Mshololo is asking for in terms of that postponement so that she can properly peruse through docket number 375 is justifiable. But he seems to be using the whole, the reasoning that his clients will be, their constitutional rights would be infringed upon in terms of a speedy trial. What are your thoughts?
No, he can't complain about that. Let's remember that the rights of all accused are equal. And it further includes the right for a legal practitioner to peruse whatever document which is available. Advocate Teffo may have preview to the docket in the earlier stages. However, Advocate Mshololo is going to say, I've only received this document now, this docket now, and it's important for me to go through it. Not only to go through it, but I also need to consult with my clients so that I can be able to construct and check, is this information going to be able to assist me? Now, let's also remember that when it comes to court etiquette and court decorum, there are certain things in which us as legal practitioners have got to observe. The very first and most basic one is that if my opponent or a person who is my learned friend is on their feet and addressing the court, my job is to sit down and listen, unless if I have a valid objection that I need to raise. And even the raising of the particular objection, it means standing up and saying or alleging the court that there's an objection that I need to raise. Let them finish. However, once they're done, I also need to address this court so that I'm able to state my submissions as they are. This process or this act of interrupting another legal practitioner while they're making submissions, it is certainly not on and does not go in line with what the court decorum and what the court etiquette should be when it comes to legal practitioners.
Now, I think a lot of South Africans are asking themselves, docket number 375, is it now going to be used as evidence? Why is the state not calling the people who were there to testify? Why are they not part of their witness list? I think a lot of people are confused about that decision and why especially they were not called for an identity parade, at least after these 5 men were arrested.
It is quite puzzling. I would have thought that after this docket would have emerged, the state would have said, can we adjourn proceedings a bit? We want to go and read this particular docket. The advantage that the state had is that all those particular witnesses and the witness statements were obtained by the state. So in essence, they are witnesses which are for the state. So you then have control as to who's going to go into the witness box or not. But the other added advantage is that when you then evaluate these two evidence and you find certain levels of contradiction, either the other individuals in which you are going to lay charges, or you're going to say you're no longer required. Now, for the state to simply relinquish a whole number of witnesses, which may have helped them at the end of the day, is a bit puzzling as to what is the strategy of the state when it comes to this particular matter. But also linked to that is the process of saying, what the state is forgetting is that once a statement has been deposed to, there's an affidavit which is on oath, information which is on oath, it can be used by anyone. The state said earlier, even the defense can go and subpoena those witnesses and say to them, come, we want to hear what you have to say, so that at the end of the day we're able to prove our case.
Mr. Zikalala, it looks to me, at least, that the defense lawyers are not on each other's side, right? It looks like they're not trying to find the same, 5 men not guilty of this crime. And looking at what Advocate Malesela Teffo is submitting today, just explain to me what he's trying to do, because it seems as though he's not accepting the National Director of Public Prosecution's explanation about these two dockets. Am I correct?
It seems though that's the angle in which he's going at. But you see, procedure and the perfect timing for you to submit that particular evidence is also crucial. You can submit it at the wrong time and it's not going to assist you. I think another classic case is the emergence of this particular, the new docket. If it was approached in the manner in which Advocate Mshololo approached it, maybe the court could have said, let me listen to what you have to say. Because at the end of the day, Advocate Mshololo was saying, I first want confirmation from the NPA that they have knowledge of this particular docket. At least if they say, yes, they do, the authenticity of that particular information and the correctness of the statements that are there, yeah, I've done half the job. So when I issue subpoenas for those particular witnesses, I don't have to prove as to how the investigation took place, because the state has already admitted that they are the ones that conducted those particular investigations, they obtained those particular statements. So if I want to use them in court, it's going to be much, much easier. So I think the approach of both legal practitioners may be a bit different. They are indeed going towards the same direction, just as the paths that they are taking. I think one is taking a much longer path, which is filled with many irregularities, which at the end of the day may end up annoying the court in terms of saying, but you know the procedure which is followed. The Criminal Procedure Act tells you what to do in instances such as these ones. In instances such as the restriction, is very clear what the law is saying. So why are you raising that point now? Also, it makes a much more easier, coherent argument if you are going to structure your submissions in a manner which is understandable and is able to convince the court at the end of the day. What the defense of Advocate Teffo won't be able to achieve is to dismiss this matter at this particular stage based on technicalities. I do not think the judge will accept that. The judge will say, I want to hear all those witnesses. There's Section 174 in the Criminal Procedure Act that allows for dismissals before even your client goes into the witness box. I'm not willing to accept any technicalities. I want to hear the evidence in its entirety before I take the particular decision.
Well, thank you very much for your expertise, Mpume Zikalala, there speaking to us about